Imagine being locked up without knowing your rights, without proper safeguards, and sometimes even without the system itself following the Constitution. Sounds like a bad movie plot, right? Well, that has been the reality for many foreign nationals in South Africa. But now, after years of back and forth, Parliament has finally passed the Immigration Amendment Bill, and it's about time. So here's the deal. Adrian Roos, a member of Parliament and the DA's spokesperson on Home Affairs, told the media that the National Assembly has officially passed this bill. And this isn't just some routine paperwork. It's a major step forward that comes 8 years after not one, but 2 constitutional court rulings flagged serious problems with how South Africa handles the arrest and detention of illegal foreign nationals. Now, let's be real. Immigration laws are tricky. On the one hand, you've got to protect the country's borders. On the other, you can't just trample over people's rights. And for years, the system leaned way too heavily toward the harsh side, leaving vulnerable groups like women and children caught in the middle of a process that was often unfair and at times downright unconstitutional. This is where the new bill steps in. The Immigration Amendment Bill focuses on creating fairer processes when it comes to arrest and detention. That means clearer rules, better safeguards, and specific protections to make sure that the most vulnerable, especially women and children, aren't treated like hardened criminals. It's about balancing enforcement with humanity, something that frankly should have been sorted out years ago. Let's not forget the context here. 8 years since the first Constitutional Court ruling. 8 years. That's almost a decade of delays, debates, and missed opportunities to fix the problem. Think about it. In that time, kids have grown from primary school to high school, and Parliament was still debating how to apply what the highest court in the land had already ruled. If government were a student, it would have failed the deadline assignment twice. But jokes aside, this bill matters because immigration touches everyone. South Africa has long been a hub for migration on the continent, and the way the country treats foreign nationals says a lot about its commitment to human rights and constitutional values. For foreign nationals, this could mean better access to legal processes, fairer treatment if detained, and more transparency overall. For South Africans, it helps to ensure that the system is working within the law, because when government bends the rules for one group, it opens the door for rights abuses everywhere. And Adrian Roos didn't mince his words. As the DA's spokesperson on Home Affairs, he highlighted this moment as a much-needed fix to a gap that's been glaring for years. It's not a perfect solution, laws rarely are, but it is a step in the right direction, especially when it comes to aligning South Africa's immigration practices with constitutional principles. So what does this mean going forward? It means immigration officers, the Department of Home Affairs, and law enforcement now have to follow stricter, clearer guidelines. It means that the rights of women and children in detention situations must be taken seriously. And it means South Africa has finally closed a chapter that's been left open for way too long. Here's the bottom line. The Immigration Amendment Bill isn't just about foreigners. It's about South Africa's commitment to fairness, legality, and the values enshrined in the Constitution. It's a reminder that even in something as tough as immigration control, humanity has to come first. And while it took Parliament nearly a decade to catch up, at least they finally got there. So next time you hear someone say, the VAT law is the law, just remember, sometimes even the law needs an update to stay fair and just. And in this case, that update was long overdue.
Now, 8 years since the first of 2 constitutional court rulings in respect of the detention of illegal foreign nationals, the National Assembly has passed the Immigration Amendment Bill. The bill aims to ensure fairer arrest and detention treatment, especially for women and children. Home Affairs Minister Leon Schreiber says the bill will lead to a raft of new regulations he plans to introduce for swifter deportation. It requires that someone detained under the Immigration Act appears before a court within 48 hours and not be held for more than 30 days. The Constitutional Court gave Parliament 24 months, which expired in 2019, to rectify the Immigration Act. This was after judgments in favour of lawyers for human rights. Schreiber says the new standards in the bill will give greater predictability to the deportation process. To talk more about this, we're joined now by Adrian, Roos, who is a Member of Parliament and DA Spokesperson on Home Affairs. Very good evening to you. Thank you for your time. I mean, the bill's finally been passed 8 years on. What does it seek to achieve?
So thanks, Mpon. Good evening. So obviously the Constitutional Court made a ruling in terms of certain parts of the old Immigration Act that were unconstitutional. So specifically, the right not to be detained arbitrarily. This is, of course, something that we want to avoid. And then also the right for the prisoner to challenge the lawfulness of their detention. And so there were a number of changes to make that happen and to ensure that foreign nationals were not imprisoned for extended periods of time before even being found or sentenced.
One of the recurring issues has been porous borders and a lack of coordination between Home Affairs and border enforcement agencies. How will this amendment materially improve enforcement without violating basic human rights?
Well, I think one of the aims is to speed up the processing of illegal foreigners that are detained. So the idea is that they will have to appear in person in court within 48 hours. And also there's the introduction of an interest of justice criteria. So as the Minister said, that he would be able to draw up those interests of justice, and that can include things like flight risk, danger to the public, humanitarian factors, the feasibility of deportation, etc. And we have a situation where there are a growing number of foreign nationals in our prisons. We are aware of the costs of this. And so what this bill does is it also provides mechanisms whereby illegal foreigners can be more quickly processed and deported.
And what about what the bill, what the amendment, does it introduce any changes to how undocumented migrants are perhaps treated in detention or deportation process? I ask this because if so, how then does the department ensure that there is compliance with international human rights standards?
Yeah, so apart from what I've mentioned already, judicial oversight is a big change. In other words, the need for a magistrate to certify that indeed the foreigner must be detained or released, because sometimes in certain circumstances an illegal foreigner might be given an order to leave if there's right to believe, and that saves a lot of costs. I think the costs of deportations are very well documented, and so you don't want to just deport and send everybody through Lindela. So that's one of the important provisions over here. As well as Section 35(2) rights. So this is the right to representation and the rights to be able to have your case heard in court. There might be certain circumstances, mitigating circumstances. And again, what we want to do is process and deport illegal foreigners as quickly as possible where it's warranted, but also avoid costly deportations where it's not really warranted.
Yeah, in fact, some critics have argued that the bill at this point is more reactive than proactive, aimed at enforcement rather than actual reform. How do you respond to such concerns that the bill may be driven more perhaps by political pressure than by evidence-based policy?
Yeah, look, I mean, this happened a long time ago. There is a reform underway under Minister Schreiber, looking at reviewing all the legislation, from civic services to refugees and asylum seekers and immigration matters. So there's going to be a number of sweeping reforms there, where one can look at the bigger picture. I think what you're seeing now, and what Minister Schreiber is doing very well, is to strengthen the Border Management Authority. Clearly, there are still funding issues there, but also there's been a dramatic increase in internal enforcement operations. And if you look at America as an example and research, it shows that internal enforcement, especially around areas of economic opportunity, are much more successful in deterring, let's say, economic migrants than even things like ICE, where you get more officers, etc. So that internal enforcement exercise, it's increased fourfold in the last year, which is quite incredible.
Yeah.
That happens in combination with what is going on at the Border Management Authority. At the borders now, there's legislation to put in one-stop border posts, which will dramatically speed up trade and the movement of persons. There's also moves to get the South African Police Service border forces into the Border Management Authority, and that will dramatically increase the volume of BMA officials that will be able to process and monitor border crossings.
You touched a little bit on funding issues. Does this mean that with this bill, it will provide for increased funding or capacity building for the Home Affairs Department to ensure that it can actually implement these stricter regulations effectively and fairly? Because also some of the concerns from other MPs were that many of the problems were due to inefficiencies of the Home Affairs Department.
Yeah, look, I think funding is important for the BMA. The whole immigration system has been underfunded for quite some time. But I think the interests of justice criteria is very important. So yes, there are funding requirements needed, but there also just need to be clear guidelines so that magistrates, for example, can process cases quicker. So interests of justice, again, it just gives you clear criteria. So those criteria of how you decide whether an illegal foreigner should be deported, detained, or released will be much clearer to magistrates as well as immigration officials. They used to be part of internal standard operating procedures inside the department. Another minister will make them publicly available. And that will dramatically, it'll make the jobs of magistrates very easy, much easier. There are often acting magistrates, etc. So having those clear interest of justice criteria will certainly speed up the process and contribute, as much as one would always like as much funding as possible for as many resources as possible.
Yeah, very well. Thank you so much. Thanks for speaking to us this evening, Adrian.